The heart of the problem is that too many principals and school board members don't know or don't understand the limits the Constitution places on their ability to control what students say, while others simply disregard the law because they don't like it. As I worked on this book, almost everybody I talked to informally said, I have a censorship story, either from their own days in school or from their children. And longtime teachers incredulously told me that they had no idea that students had First Amendment rights, and they asked where I had come up with such a creative notion. So, in proceeding, I have to begin by giving you a whirlwind tour of First Amendment doctrine as it applies to students. And then I'll turn to some stories that capture some of the particular contemporary dilemmas. The speech clause of the First Amendment is very concise. It says, Congress shall make no law abridging the freedom of speech. As interpreted, this means that the government and anyone acting on behalf of the government may not silence speech because of its content or viewpoint. School districts and everyone who works for them, from principals to teachers to school bus drivers, are the government when we talk about students' freedom to speak. My research and my comments today are limited to public schools because the First Amendment doesn't apply to independent schools, whether secular or religious. They're not the government. The Supreme Court first took up the issue of student speech rights in 1943, in one of the earliest cases in which it actually upheld the speech rights of any individual. Barnett versus West Virginia involved elementary school students. They were Jehovah's Witnesses who were at risk of expulsion and being sent to a juvenile reformatory because they refused to say the Pledge of Allegiance on the ground that it offended their religion. But it was not litigated or interpreted as a religion case. The consequences today of speaking up and being punished can also be dire. Many students enter the school-to-prison pipeline as a result of being suspended, expelled, or sent to an alternative school for troubled students after they engage in protected speech. So just like the Jehovah's Witnesses in 1943, the consequences are stark. Barnett held that people, including young students, could not be forced to say what was not in their minds, a concept we today called the rule against compelled speech. The court emphasized the constitutional limits on the state's coercive powers, whether exercised by, quote, village tyrants or by the federal government. And it underscored that the First Amendment was designed to protect nonconformists of all stripes. The court particularly focused on schools because the case involved 2 elementary school girls. It said, because schools are educating the young for citizenship, they must scrupulously protect individual rights if we're not to strangle the free mind at its source and to teach youth to discount important principles of government as mere platitudes.